Good morning. Welcome to WorkLaw's subscriber webinar. My name is Bruce Robertson. On my left, your right, Alan Rycroft. And we'll be talking to you probably for the next 75 minutes. Our agenda is firstly to discuss key changes in the legislation from the past year, and then we'll move on to looking at the landmark judgments that we think are worth talking about from the past year. Please, if you have any questions whilst we raise issues, use the Q&A function at the bottom of your screens. We'll deal with all the questions at the end. So after about 75 minutes, depends how long-winded Alan is, we will deal with your questions as best we can. Please keep the questions quite short. We haven't got time to go into like major factual issues. So just give us the crisp principles that you're asking about, and we'll do our best to try and answer them. There's no need to take notes. A video of the webinar plus a very comprehensive manual which covers all the issues that we're going to be speaking about will be available up on WorkLaw quite soon after the webinar. So we'll send out an email and you'll be able to access that from that point onwards. Anything that I also need to cover before we start, Alan?
No, I think that's it.
Okay, let me kick off. I'm going to firstly chat to you about the draft employment equity sector targets that were gazetted in February of this year. They are in draft form, if I can make that point to begin with, and the public is entitled to comment up until the 2nd of May. So there's time to still get your views in if you wish to comment. They set targets, employment equity targets in 18 sectors across the country. These range from agriculture through to finance, through to retail, through to the public sector. And they set employment equity targets in the top 4 levels of the organization. That's top management, senior management, middle management, and skilled. The significance of them is that in order, what's set out in the sector targets is that you would, if you comply, you get a compliance certificate, and a pre-requirement for doing business with government would be that you have a compliance certificate. So the potential is there that apart from other penalties under the Employment Equity Act, unless you're compliant, your ability to do business with government might be significantly hampered. I'll speak later about some of the criterion that might or might not apply in determining whether you're compliant or not. These are not the first set of sector targets that were gazetted. There was a previous set gazetted last year, and let's firstly look at a comparison of what's new. I'm going to share screen, and let's look at what's new under the employment equity targets, this year's version compared with last year. Firstly, there's much more guidance that's given to you in the Gazette. So you've got much more guidance about how the targets were formulated and how they should be interpreted and applied. And that's obviously helpful. Last year in the sector targets, they provided national and provincial sector targets. There's now just one national sector target in each sector. So one national target in each sector. And last year, they broke down those targets into African, coloured, and Indian employees, and there were sector targets for each population group. There's now just effectively one black employee target in each sector, and there's also there was a female target last year as well, and there is a female target there as well. By the way, the female target would be met by someone in any race group who falls into the female target. But when you look at the regulations, at the guidelines, they still require employers, when they set their annual workplace targets, to set targets for all population groups in each occupational level. So we would read population groups as being African, coloured, and Indian, and you then, despite the fact that there's one national sector target, you would have to break that down, I think, into the various population groups. And there's significant emphasis placed on the EAP stat, the economically active population stat, on a national basis, a regional state basis, or a provincial basis. And here I think there's potential for much confusion, because if you think about the EAP, the economically active population, it's going to vary significantly between sector to sector. The EAP in the agricultural sector, for example, is going to be very different to the EAP in the finance sector. Also, I'm not even sure if these stats would be available, but the economically active population in senior management might be very different to those in middle management, say in the finance sector or in the agricultural sector. So there's significant issues here. Plus, think about the EAP, the economically active population in Durban, compared to the rest of KwaZulu-Natal, compared to the rest of the country. Similarly in Cape Town. So by having the focus on the EAP and an employer setting its employment equity targets based on its applicable EAP, and I'm not going to go into all the details, but in the guidelines, there's mention of if an organization is countrywide, which EAP it uses, if it has the majority of employees in one province, which EAP that does it use, etc., etc. But the point I'm trying to make is that the EAP, by using that as your criterion for setting workplace targets, you could well end up at a very different position to the national sector target. And I'm going to come back and talk about that in more detail just now. What's also interesting is that the national sector targets in the most recent version of the Gazette were very, very similar to the version last year. I think only in one sector, in the finance and insurance sector, was there any change in the national sector target. And despite the differences between the various areas of this country, the national sector targets across the board are very, very similar. Let's just have a look at some of these. In top management, the national target is between 40 and 50% in 14 out of the 18 sectors. That's 78%. Senior management, the targets are a bit higher. There they are. And again, in 14 out of the 18 sectors. The next level down, middle management or professionally qualified, the targets are higher, 60 to 75% in 11 out of the 18 sectors. And in the last grouping, the targets are even higher, 84 to 91%, here in 15 out of the 18 sectors. So there's a lot of overlap between the targets in the various sectors, despite the differences in the makeup of those various sectors. So, I mean, I think that gives you a broad sense of what's contained in the sector targets. An extremely important aspect, I mentioned that last year when these sector targets were published in the Gazette, there were legal disputes, solidarity lodged a dispute that went to the ILO that was settled out of court effectively with government on the understanding that aspects of the settlement agreement would be incorporated into the Gazette when the sector targets were updated. And that's happened. Clause 4, I think it is, of the Gazette deals specifically with the contents of this agreement that was reached with the union. And some of the key points that emerges and which are now contained in the Gazette is that affirmative action is a temporary measure. That obviously then raises the question, well, if it's temporary, when is the end date of the temporary measure? Secondly, and this is obviously directly out of the Employment Equity Act, there should be no absolute barriers to employment for employees of any race group. Justifiable grounds are set out for not meeting the sector targets, and they include recognition of the realities of what organizations face in the workplace. In other words, if there's insufficient recruitment or promotional activity opportunities, and if there's no turnover in that particular organization. That would constitute justifiable grounds for not meeting the sector targets. And there are no penalties if justifiable grounds exist. So in other words, going back to the point I made earlier, an organization could not be refused a compliance certificate if it had justifiable grounds for not meeting the sector targets. And importantly, there should be no terminations of employment as a consequence of affirmative action. I attended one of the big labor law conferences last year, and one whole session was devoted to whether an employer could retrench in order to achieve sector targets. Well, this clause under clause 4 of the Gazette would certainly put an end to those kind of arguments. So I'm going to move on quite quickly, but 5 key takeaways from the most recent version of the sector targets that were published. Firstly, they are still a draft. There's comment by the 2nd of May, so these may not be the final picture. We have to wait and see what emerges. Secondly, those targets I mentioned, some of you may think, well, those are not that difficult to achieve, particularly taking account that it's Black employees plus female employees would make up those sector targets, and it would be female employees of any race group. But there is still confusion over the implementation. As I've mentioned, I've tried to draw that out to you with the potential difference between the national sector targets as they've been published and the economically active population stats per region, per area, etc. Those aspects of that agreement with the union that were incorporated, they're important. And lastly, there's still a potential legal challenge. Surprising as it may seem, these sector targets were gazetted under a section of the Act that has not yet been brought into effect. How do you publish something that under a section of the Act that doesn't yet apply? You can see that there's potential for a legal challenge there. So those are the 5 key takeaways that I think you can take out of this, this aspect. If you have any questions, please ask them and we'll deal with them at the end. Okay. Alan, over to you.
All right, I'm going to start with this story and then get on to the explanation.
Alan loves stories.
Often in law, it's unusual circumstances which challenge the law as it stands. So this case involves a Mr. and Mrs. Van Wyk, and Mr. Van Wyk's a salaried employee. His wife, however, runs her own business from home, and when she fell pregnant, she knew that she couldn't afford to take any time for maternity leave. She needed to keep working on her business from home. So it was decided that Mr. Van Wyk would be the primary caregiver of the infant when it was born. Now, Mr. Van Wyk discovered that in terms of the Basic Conditions of Employment Act, all he was entitled to was 10 days parental leave, and that wasn't even paid by the employer, it wasn't paid by UIF. He managed to cobble together some annual leave and so on, but he eventually challenged the existing Basic Conditions of Employment Act, which we all know so well, and it's for years and years seemed quite fair.
Would you like me to put it up?
Yeah, and so just as a reminder what these sections are that he's challenging. So the current ones, as you know, maternity leave is 4 months for birth mothers. Now you can see the problem with that if you've got, for example, a father who, like Mr. Van Wyk, who wanted to take care of the child, he is not eligible because it's about mothers. Parental leave, 10 days for fathers. Then, rather strangely, adoption and surrogacy leave was not 4 months, but 10 weeks. Now, when these sections came in, there were some questions raised. Why would you discriminate against a person who gets a little baby, might just newly born, and not get 4 months? Why only 10 weeks? So there were already some inconsistencies. Just to take you through the adoption and surrogacy leaves, these are actually gender neutral. One parent gets 10 weeks leave, the other gets 10 days parental leave, and either parent can take that. It's their election. So it was the way the Van Wyk situation just didn't fit with this at all that led to a challenge. And when this matter went to the High Court, not the Labour Court, and the High Court declared these provisions to be unconstitutional and invalid. Now, just before I go any further, to tell you what the court recommended, when all courts are given the power to declare things unconstitutional, but that doesn't mean the Act becomes unconstitutional. The Basic Conditions of Employment Act remains in force as it is today. But it has to go to the Constitutional Court to confirm the invalidity of that section.
And that hasn't yet happened.
It hasn't yet happened. I keep on checking to see if the Van Wyk case is on the roll at the Constitutional Court. It's not there. So it's already like a year after the judgment. And so, Bruce, I think we don't have to be sort of worried about this being sprung on us. And then, of course, just what the Constitutional Court will do is declare it unconstitutional, and then it goes to Parliament to amend the Basic Conditions of Employment Act. I think we are years away from resolution, but we have.
But didn't the court say, pending, once the Concord has confirmed it, obviously,
there's a default position.
There's a default
position. Which we'll see in the new slide here. So the changes subject to the Constitutional Court confirmation is that a single parent or a pair of parents collectively are entitled to 4 months parental leave. So you can see how that gives a lot of options. Mr. Van Wyk would come in under the single parent or under the pair of parents. It applies to any parent configuration, whether it's male, female, and whether it's a partnership or not marriage or whatever. And they can elect how to share it. So that's the essence. This is putting it in sort of like easier language than the court framed it, but you get the gist. It's now, yes, so this is something I want to talk about. Both employers must be notified in writing before the birth how it's to be shared. So we think this is going to be one of the big problems of this, or when the Act, when it finally changes and leads to the issues to consider. How will the one employer, say who employs the father or the father, how will they verify when he says, I want to take the 4 months? How will they verify that the mother is also telling her employers? And
because it's most unusual that both parents will be working in the same organization.
Yes, that's right. And that raises all kind of questions about how this should happen. Next thing is, well, we want a solution to the first point is we think that you should consider as employers developing a parental leave form which consents to contacting the other employer, which is necessary because of POPIA, the act which prevents the information being spread too easily, with a warning that false information is a serious misconduct, because I think it's foreseeable that some parents will both apply for 4 months. And that's what the Act does not allow. Okay. Now, you might be involved in with an employer who's got much better policies than the BCA. You might remember the BCA maternity leave is not paid for by the employer. It's paid by you, the Unemployment Insurance Fund. But many employers do, in fact, pay for at least part of the 4 months maternity leave. Now, even though it seems to be far more generous, we believe that those policies are going to be equally scrutinized by courts to see whether they're discriminatory against the other gender. All right. And we think that there are going to be cost implications. If you as an employer don't know if your male employees are suddenly going to want 2 months maternity leave, sharing the other 2 months with the wife, that's going to have a sudden cost impact if your pattern in the past is to, in fact, pay for maternity leave. Well, it's now going to call parental leave. So,
and you then into potentially having to change your policies, because of the cost implications, and you then have to look at your rights to change policies where these may have been agreed, and so on.
Exactly. So I think you might think it's very premature to even worry with this because it hasn't got to the Constitutional Court, hasn't got to Parliament. But I think it's still an interesting thing for employers to look at their parental or maternity leave policy and realize that it might need modification and it might need a renegotiation.
Okay.
Yeah.
All right. So those are the areas in our law that we think was important to focus on. And we're going to look at now some of the landmark judgments that have come through in the last year that we think are worth talking about. I must tell you that if you hear a strange noise, the cat has just walked in the room. So if you hear a meowing, it's our deaf cat that's just walked in the room and demanding attention. So I apologize for that. I'm going to ask you a question to start with, and it goes to a recent judgment that challenged how dependable breathalyzer tests are.
So the poll question is a positive breathalyzer test on its own reliable proof of being under the influence of alcohol? You've got a yes, no choice.
Now, can I just say, we're going to ask you, just to keep you awake, we're going to ask you various questions during the webinar. We don't see your individual answers. We just see the percentage of how many of you vote yes or no. That's all that we see. So 5 more seconds, and then I'm going to, so just make a guess, and I'm going to end the poll. Share your results. I hope you can see the results. 79% of you say no. Well, let's look at this case. And in this case, it's a. I don't think they see that, but it's a cement or chrome case from last year, and it found that a breathalyzer test is capable of producing false positives in certain circumstances. For example, if a person hasn't eaten for 8 hours before, or if they've eaten yeast in the few hours before the test was conducted. And it found that a blood test is a much more dependable test. Now, it may not surprise you that the Worklaw Helpline, we have now a lot of queries where employees and their unions are claiming when someone tests positive for a breathalyzer, oh yes, I ate yeast a few hours ago, and that's probably the reason why I'm testing positive. In fact, there's a recent arbitration award that's been referred to us, where the employee said he had eaten a substance which he thought might contain yeast. On the basis of that, the arbitrator confirmed that the dismissal was unfair and reinstated the employee. One of the basic principles, if you allege something, you must prove it. There was no evidence on what precisely the employee had eaten, on how much yeast it contained, what impact that would have on the employee's test, etc., etc. So yeah, let's also look at the specific facts in this Chrome case on how the court came to find as it did. And the facts of this case, yeah, you had an employee with 19 years service, clean record. He comes to work, he breathes in a breathalyzer, and it tests positive. He immediately disputes the test and says, listen, I've consumed no alcohol at all. And he demands a second breathalyzer that also tests positive. He then dashes off to his local GP, has a blood test, which is negative. The employer, oddly enough, also conducts a blood test and sends it off to a lab, and that is also negative. So you've got a case here where you've got 2 negative blood tests and 2 positive breathalyzer tests. Notwithstanding that, the employer terminates the employment of the employee, and he challenges it, goes to the CCMA, and the arbitrator said, look, this seems unfair. There were 2 blood tests, they were negative, I'm going to reinstate. The employer takes it on a review, and it's on those facts that the finding in this case was as follows. Firstly, the court said that the onus is on the employer to prove that there was a positive test. If you allege something, you must prove it. And it confirmed that breathalyzer tests were capable of producing false positives and blood tests are more reliable. There was at arbitration, the employer called a pathologist who gave this expert evidence. The employer's witness gave this evidence. So in fact, I mean, what more did the arbitrator or the court need to, what more evidence did the court and the arbitrator need to confirm these conclusions? So how should employers deal with this? We've got some other ideas. Firstly, if an employee tests positive in a breathalyzer tests, we think you should immediately raise with the employee whether he disputes the result or not. If he doesn't, if he accepts it, well, then I think it can be taken as proof. If he disputes it, I think you need to immediately arrange a blood test and see what those results are. It's also important to gather other supporting evidence. These are all just, these tests are all going to prove whether the person is under the influence or not, or whether they failed a test or not. And you can gather other evidence. Was the person unsteady on his feet? Was his speech affected? He or she smell of alcohol, etc., etc., etc. And there's an old judgment which we've got on work law, which says when you basing a conclusion on these tests, you've got to prove the dependability of the test. So produce evidence as to when the machine that was used was last serviced or tested, that the person conducting the test has the ability to perform the test, etc., etc. And also think about what charge you're going to use in these circumstances. Are you charging an employee with being under the influence of alcohol, which you then have to prove, or are you merely charging the person with having tested positive in a test, which in your terms and conditions of employment, you could equally make a term and condition of employment. So those are just some issues to think about in order to deal with this case. And I think it's important to recognize that court came to its conclusions based on the particular facts of that case.
Okay, we're moving on, and I want to talk a moment about two cases involving delays in disciplinary proceedings. And it's really asking this basic question: at what point do you think and it becomes unfair if the disciplinary inquiry is delayed? Is it 6 months? Is it 9 months? At which point do you think it starts to prejudice the employee? Because that's usually the test of whether it's unfair or not.
Try and have a figure in your head before Alan goes on with the facts of the first case he's dealing with. So I'm not going to ask you, there's no question on it, but is it 6 months? Is it 2 months? Is it a week? Is it a month?
Well, in this case, it's so scandalous that you wouldn't guess that this, in this case, the Passenger Rail Authority case, there was a really nasty altercation at work involving a group of workers with their supervisor, and they were eventually charged with serious misconduct, insubordination, and operation sabotage, which sounds very serious. And then nothing happened. They were never suspended. They continued to report to the same supervisor. There was no evidence of further incidents of sabotage and things like this. Suddenly, out of the blue, 2 years and 4 months later, one of the 4 employees is taken to disciplinary inquiry and she was dismissed. So that you can see that a lot of things that cross your mind, why 1 out of 4 and so on. But goes to the CCMA, and who found the dismissal to be both substantively and procedurally unfair, and it went on to the Labour courts. And look, I'm not going to deal with the substantive fairness of this case because there's a complicated, as I say, altercation between the supervisor and the employees. But when it came to the procedural fairness, the Labour court gave some clear principles. Maybe we can put these up of what's expected as far as delays. The questions the court says that must inquire about is the length of the delay, the explanation or excuse. Now, that the explanation often is, in my experience, we're dealing with a highly complicated fraud operation here. We're having to go through so many computer records and so on. So you can see how some investigations are going to be longer. Did the employee take steps to protest and say, look, you can't keep me hanging and dangling here. You must make a decision. The next one is there material prejudice to the employee? Normally the prejudice to the employee is witnesses in their favor have left or disappeared, or alternatively memories are weakening. So the longer the matter's delayed, it starts to impact on evidence. And then of course the nature of offence, which I really referred to in the explanation. This case made clear that delay in itself is not sufficient. There must cause prejudice. And in this case, the court was quite happy to say that it wasn't going to alter the arbitrator's decision, that this was procedurally unfair. In this case, 2 years, 4 months was just too long. And there was no explanation for the delay. So the very first thing, that what explanation have they got? They had none.
Okay, and what was the consequence of the procedural unfairness of this instance?
She was reinstated.
Okay.
Yeah. All right.
Do you want to compare that with what happens in the public sector?
Yeah, just before I carry on, just think in your minds, is there any difference between private sector and public sector in this matter? Is a misconduct in the public sector somehow different? Because in the next case, Sabani's case, there were serious allegations of misconduct involving alleged breaches of the Public Finance Management Act. So there was some quite serious applications. And once again, the charges were laid, but nothing happened. And I don't know whether there was rumors that they were about to start a disciplinary inquiry, but nevertheless, the employees went to the CCMA asking for, in fact, it was to the Labour Court, not the CCMA, to the Labour Court. They asked the court to, what's the word, quash the charges, in other words, declare them void, because they hadn't been brought for a period of 3 years. Now you can, 3 years later, when there's a serious charge. Now, I think at this stage, on the facts I've given you, you think, well, 3 years, nothing done, surely there is no excuse. So I want to bring it back into focus for the public sector, because the court did see this as a really important aspect. The difference here is that we as taxpayers there's a societal interest in perpetrators who've mismanaged finances being brought to book. It's not like a private sector where you might overlook something or realize that no one else is going to be impacted. Here, there's very definite considerations. And what the Labour Court said, there's got to be what the strange phrase, insurmountable trial prejudice, which I think is the same as prejudice to the employee. But they use the word insurmountable. So yeah, I think it is insurmountable if your evidence has gone missing. That's pretty insurmountable. You can't lead the one person who could vindicate you. But they put a very high level before they appeared to quash the charges.
Okay.
Yeah.
All right.
So we
see that there are slightly different factors which come into play where these occur in the public sector.
Yeah.
Okay. What's just one comment? I mean, I think it was that case. What's really sad is how long that whole process took,
Yeah.
and that the court in itself took 18 months to give its judgment. So not only were the parties involved prejudiced, the court itself took 18 months to
really shocking. Yeah. I want to carry on now in the same area of discipline to talking about deciding sanction. I think one of our most common questions on our work law helpline is is dismissal an appropriate sanction for this? And we give a little scenario and we try and offer some perspective on it. But I think it's one of our most frequently asked questions.
Yeah.
And it is quite interesting to know what factors should be taken into account. In the first case, which is Sabaya Gold Limited case, there was a strike, a protected strike, run by UMCU members, but National Union of Mine Workers members were not on strike. And so it turned out to be an extraordinarily violent strike with lots of intimidation of NUM members, and it was quite intolerable, the whole situation. And this case focused on just two people, one person who was continually harassed by an UMCU member, coming to his house with weapons, threatening him, calling him a rat, saying he was going to suffer. And eventually there came a situation where they met on the road. The UMCU member had a stick and made an attempt to assault other people surrounded, pulled them apart. And so this employee from UMCU was charged with attempted assault and other offences. There was no difficulty in both the CCMA and the Labour Court finding that the dismissal was substantively fair. But the point was raised at the Labour Court that at the CCMA, the employer had never led any evidence that the relationship between the UMCU member who was dismissed was in any way broken down. So we returned to a theme which I think we've dealt with this quite often over the years, that must an employer lead must the employer lead evidence that the trust relationship is broken down, and is that a requirement? This case has confirmed what other cases have held, that when there's gross misconduct, it's not necessary to lead evidence about the breakdown in trust. It's implied from the nature of the offence that trust is broken down and dismissal is appropriate. So when you have an employee who's going around sort of intimidating other employees, attempting to hit them with sticks, it becomes, I think, fairly clear the relationship. You can't trust that employee anymore. Another factor which arises in another case, Governor's case, it really is interesting how sometimes we read the facts for new cases and they always take you by surprise. In this case involves a group of employees who didn't want to transfer premises within the city of Durban from one office block to another. And they decided to stay where they were until their access to the old building was taken away. They couldn't do any work there. And they were given an ultimatum: turn up to work or there's going to be trouble. And for various reasons, they didn't comply with the ultimatum and were dismissed. Now you think, hang on, how serious is this? These are people who have got quite long service. They've been reliable employees at all this time, and they haven't come to work. They're 2 days late out of the. So this case was really trying to explain what should have been taken into account. This is the Labour Appeal Court in deciding sanction, and they usefully used 3 words. A decision maker should consider the nature, the magnitude, and the impact of misconduct. I just want to break that down.
Can you give us examples and
each one?
one?
So the nature of the offence, and I think particularly if there's some kind of fraud or dishonesty involved, you know that it's a different kind of nature to employees who are reluctant to move to new premises. Magnitude is a strange word to use, but I think that does refer to the loss or damage to the employer. If the fraud has caused, R1 million loss, it's different to the employer here in this particular case, where in fact there was no real loss to the employees not coming because they weren't paid for the days they were there anyway. And the impact, that is really the impact of the misconduct on the employment. Has the relationship broken down? So this might be useful for chairpersons of disciplinary inquiries to use what the Labour Appeal Court has advised, to consider the nature, the magnitude, and impact before deciding on dismissal. All right, Bruce, so I'm carrying on.
One last case. If you're getting bored with listening to Alan, he's got one more case to deal with.
No, just right now. you will probably know that the Labour Relations Act says that there need not be reinstatements. This is where the dismissal has been found to be unfair. There need not be reinstatements if the circumstances are such that a continued employment relationship would be intolerable. All right, that stands to reason. If the employer can lead evidence that there's no way we can go forward, sure, the dismissal might have been unfair for some reasons, but we've broken it. We don't trust this person at all. That's usually the kind of thing. In this particular case, at the very first stage of the CCMA, no evidence was led at all about the intolerability of the continued employment if the employee was reinstated. Only at a very much later stage did the employer argue. It was not evidence, it was argument, closing arguments, that it was intolerable. In this case, it was. Please do. The Labour Appeal Court, in this case, said, well, first of all, it confirmed earlier cases that intolerability has got a very high threshold. It's not easily reached. You've got to really show that it's actually intolerable. But here's the important learning from this case. If the employer's case is that reinstatement would be intolerable, the employee must be advised of this quite early on so that they can lead evidence on the issue. So when the employer's leading their case right at the beginning, they presumably are leading evidence why the relationship will be intolerable, and the employee then is alerted to the fact that they must lead evidence why it's not intolerable. So that's, I think this is the important lesson. Well, can I say that you see this last thing is the fact that the employee, look, I think there's no doubt in this case, the employee was set up in some way and faced huge charges, and it does seem as if there was a conspiracy against him. And he persisted in his evidence saying this is all a conspiracy. And the employer argued that the fact, if you have an employee who keeps on saying it's a conspiracy against me, that does not establish that continued employment would be intolerable. So I think it's saying that the employee.
Because in fact, in this case, Alan, am I right? The Labour Court said, well, because there was he said there was a conspiracy, how can I put you back into the job when there's conspiracy against you? So used the very wrongdoing by the employer's side as a reason not to reinstate. So he was awarded compensation by the Labour Court, wasn't he?
Correct.
Which was then overturned by the Labour Appeal Court.
Correct.
Okay. Yeah.
Okay. Bruce, I think you can finally deal with the case of your own now.
All right. Let me earn my wages for the morning and chat to you about a case of constructive dismissal. I'm going to ask you a question first to make sure that all of you are keeping awake.
The question is, can an employee claim constructive dismissal when conflicts with other employees has made continued employment intolerable?
Look at the words carefully and see if you agree with that or not, and vote. I'll give you about 10 seconds to make up your mind. As I've said to you, we don't see your individual answers, so you can be as right or wrong as you like. We don't know. All we see is the percentage of you who are voting yes and no. All right, let's end the poll. Let's share the results. And it's exactly 50-50. That's very interesting. Okay. I'm not going to give you the answer yet. I'm going to look at the facts of this case. It's a case involving Westbank. It's a Labour Court judgment this year, in January of this year. And these facts are interesting and somewhat amusing, perhaps. But this was an employee employed by Westbank as a specialist fraud and risk investigator. He had a very senior job doing some very specialized fraud and risk investigations. He worked for 17 years for the bank. He had a clean record, There was a change in the management structure and the person that he reported to. And it's from that point that things started to go a bit sour. He sent an email to his manager where he referred to him in jest as the master of the highest order. How would you like getting an email? And this was sent to other employees as well. His manager said, please don't call me that. Use my name. And he then sent him a second email calling him the wise master of the highest order. He was a bit of a joker, this guy. He said there were some tensions in the department and he was trying to lighten the mood. He was a master. He was a guy who was used as a master of ceremonies at certain bank award ceremonies, and he would perform a roast of certain senior managers as a sort of joking thing, and it was seen in that light, and maybe that was what he thought he was doing. He realized he'd gone too far. He apologized, but he was aware that disciplinary action was going to be taken against him as a result of this. And this was hanging over his head. It hung over his head for quite some time. He knew it was being thought of. He eventually then approached his manager and said, listen, I mean, are you taking action against me or not? And the manager said, no, they decided to put the issue to bed and take no further action. And sadly, rather than that ending the matter, he sort of exploded in that conversation. He said he was so pleased, but he felt there was a sword hanging over him and he was not in an effing good space. Now, the manager then did take disciplinary action against him for use of his language. So rather than ending the matter, it now ended in disciplinary action being taken. And he was given a final warning for his behavior and his language. He then lodged a dispute against that, referred it to the CCMA. So he took his employer to the CCMA, saying it was an unfair labor practice. And at the CCMA, the final warning was reduced to a written warning. Well, that started a downward spiral. I'm not going to give you all the facts, but over the next 6 months, he lodged 6 grievances against his manager, which were not pursued actively by the organization. He was given poor performance ratings without any consultation. He applied for compassionate leave when his mother had a stroke. This was turned down without any reasons being given. His manager started to tape record phone conversations with him, whereas he's never disputed the contents of those conversations before. He was excluded from certain social media groupings. Certain work was taken away from him. There was just a downward spiral and a deterioration in the relationship between him and his manager specifically and the organization at large. He then wrote to the CEO and said, listen, I want help with these grievances. Please, can you help me? I want these grievances that I've lodged and no action's been taken. The CEO wrote a formal response without dealing with any of the issues. He wrote a second letter to the CEO. He got no response and he resigned and claimed constructive dismissal. That's in a summary what happened. It went to arbitration. The arbitrator agreed he'd been constructively dismissed, and he was awarded 10 months compensation. The employer took it on a review in the Labour Court, and let's see what the Labour Court had to say about this matter. It confirmed the requirements for constructive dismissal. Firstly, it must have been the employee who terminated the contract because continued employment had become intolerable, that term that Alan referred to earlier, and this must have been caused by the employer. So in the example that we asked you about just now, where there was tension caused between other employees, not caused by the employer, that would not have constituted grounds for constructive dismissal. And the Labour Court in this case confirmed that there's both a subjective and an objective aspect to the test. So it's viewed from the perspective of the reasonable person, an objectively reasonable person, but in the shoes, in the subjective shoes of the employee. So there's both there's both a subjective and an objective aspect to the test. And as Alan mentioned, there've got to be compelling reasons required. It can't just be that things aren't going that well. It's got to be at breaking point. And I think that's one of the important aspects of this case. Okay, I hope there's some useful learnings there.
But Bruce, I'm going to take you back to the poll question was, can an employee claim constructive dismissal when conflict with other employees has made continued employment intolerable?
You obviously weren't listening. I mentioned
no, but is there a difference between the manager is the main source of conflict? Then it's easier to say the employer has caused the problem. If the other employees involved, that's why I think there was a 50% split in the poll.
Yeah. Look, I mean, I think we used those words on purpose, that it was just merely a dispute amongst the employees.
Yeah.
There was a breakdown in their relationship. Once you have managers involved or the CEOs involved, then it certainly becomes into the ambit of the employer.
Yeah, that's right.
A further interesting point about this judgment was that the court commented that there were no mechanisms, that this thing hadn't broken down over one issue, or that it appeared one issue may have begun the breakdown. It had just taken place over a period of time, and there were no mechanisms in place to try and repair the broken relationships. Now, if they'd called in an outside mediator, someone from PISO as an example, we think that would have been a very constructive way of perhaps dealing with this early on, and which might have prevented this spiral of events which then took place.
Yeah. So we're moving now on to away from dismissal law into strike law, and I want to talk about a case where the employers Trendstar. There was a protected strike that lasted several weeks. It was for a particular demand, a once-off payment of 7,500 rand, and after 7 weeks with no movement from the employer, NUMSA suspended the strike. And the employer was left uncertain what suspended the strike meant. Could it start again the next day? And so in response to that, the employer gave notice of its intention to lock out the NUMSA members until they dropped the demand for this once-off payment. And they started using replacement labor, or it's sometimes called scab labor. And you might know that the Labour Relations Act, rather out of step with international law, in section 76, it allows replacement labor during a lockout, where the lockout is in response to a strike. That's important. The lockout is in response to the strike. So this case went all the way to the Constitutional Court to decide whether the lockout was in response to a strike where the strike had been suspended. So maybe we can have a look.
Maybe I'm not going to prove that because they've now gone out of sequence, but don't just mention the principle.
All right.
Perhaps.
So the Constitutional Court looked at the definition of a strike, and it's certainly, it has to be an obstruction of work at that moment in some form, a retardation or obstruction of work. And when the strike's suspended, there's no strike. And they said the implication of that was that the employer could not then have a lockout, and therefore it ordered it to be set aside. So
the learning from that case
was basically the definition of a strike does not include a suspension of a strike, and therefore you're not allowed to have a lockout. A lockout will not be in response to a suspended strike.
Well, you can't use replacement labor in that instance.
Yeah.
Okay, I'm going to chat to you about does violence during a protected strike potentially render that strike unprotected?
Do you want to use a poll?
Yeah, I'm going to use a poll here to ask you a question.
The question is, can violence by strikers render a protected strike unprotected?
Tell us what you think. assume there's extensive violence during a protected strike. What impact can that potentially have on the protected nature of that strike? Give you another 5 seconds. Going, gone. End the poll, share the results. And there you're seeing that 67% of you say yes.
You better explain yourself, Bruce.
Well, let's look at the facts of a sad case. This is a case involving Shaven Gibson packaging in the Durban area. There was a protected strike over a wage dispute. There's extensive violence during the strike. Vehicles are stoned. The home of a non-striker is firebombed. There WhatsApp sent to people who are still working, which read as follows: "We are tired of you all working while we are not working. What is next is the death of yourself and your family." That type of conduct was taking place during the strike. The employer eventually dismissed a whole bunch of employees. I'm not going to cover all the charges. The one I want to focus on in particular is that they were taking part in an unprotected strike. And the employer had argued that the protected nature of the strike had become unprotected for a number of reasons. And let me put up a slide on this. Amitu versus Shaven Gibson packaging. And the Labour Court said the strike does not lose its protected status due to unreasonable demands made during the strike, its length, because it went on for a long time, and the high levels of violence. I think the first two are fairly uncontroversial, so I'm not going to spend time on those. But it's this third one, the high levels of violence and intimidation. There have been 2 previous Labour Court judgments that have acknowledged that a strike does potentially lose its protected status due to the high levels of violence during a strike, and that it can then be declared unprotected. But the problem that the court faced in this instance was that since and subsequent to those 2 Labour Court judgments, there was another Labour Appeal Court judgment involving Nahawu and the Minister of Public Service and Administration, which last year said no, a strike does not lose its protected status due to violence. And it quoted a constitutional court judgment, and it was based on the views that the minority of employees who are behaving themselves and who are exercising a protected right to strike would then lose their right to strike, which is enshrined in the Constitution. So I'm afraid this case, it's a Labour Court judgment. We are hoping, and we have no idea if they will, but we're hoping that the employer takes this on a review in the Labour Court so it can be dealt with by a higher court again, because we really, Alan and I, just don't feel that this judgment takes account of the realities of the shop floor. I mean, if you think about it across the board, in the Labour Relations Act, there are a number of instances where the behavior or the conduct of the majority trumps and outweighs minority rights. I mean, you think about an employer that's having to consult with a majority union over a retrenchment. There's no obligation in law to consult the minority union. Think about the legal effect of a collective agreement that's concluded with a majority union. That, if you comply with the Labour Relations Act, can have it extended to cover all employees in the bargaining unit, and it changes and affects the individual contracts of employment of minority unions. So we think that there are a number of ways in which the majoritarian principle permeates through labour relations under the LRA, and we think inappropriate circumstances where there is extensive violence being conducted by the majority of people on strike. We are supporters of the view that that should affect the protected nature of that strike. But we're faced with this latest Labour Court judgment that has found otherwise. And so that's, I think, important for employers in this instance. Because of again, I'm not going to go into, haven't got time, but the difficulties in proving common purpose and those other aspects of behavior during strikes and the court's rulings on those issues, all that you're left with as the employer is to collect as best you can clear evidence of strike violence. You should have a team, whether it's one person or a group, who is collating this evidence during a strike so that you can still pursue charges of misconduct against those who are responsible for the violence and misconduct that's occurred during the strike, despite it having a protected status. So yeah, I mean, that case is there. We don't like it, but it's there.
Still within this area of strikes, but quite an unusual set of circumstances. In a particular unprotected strike action, the employer wrote to the employees who were on strike, warning them that it would be no work, no pay. And this was repeated again. But this was a Northwest provincial legislature, so public sector. Somehow the message didn't get through to the payroll officers that they had to deduct wages of those who were on strike. And so everybody got paid their normal wages. And when the employer discovered that the usual penalty for being on strike, no work, no pay, was now been thwarted, it then tried to recover the money by deducting 3 days' wages each month until it had recovered the money that it should have. And this then locks into the Basic Conditions of Employment Act, Section 34, which deals with the deducting from the employee's salary. And the law is very clear in the Basic Conditions that there's got to be an agreement in writing for the employer to deduct from the employee's salary. And in this case, the court was quite clear when it went all the way to the Labour Appeal Court, which confirmed that in fact there was no agreement in place. It wasn't in writing either. There was no law or arbitration award, and therefore the employer had no right to unilaterally start deducting. Now I think we're surprised that the advocates for the employer in this case didn't raise a section in the Basic Conditions of Employment Act which permits the employer to operate to deduct where there's been overpayments made by the employer resulting from an error in calculating the employee's remuneration. I think that was probably wide enough for the employer to say we are acting within the course or within the scope of the Basic Conditions of Employment Act. That argument wasn't raised, and I think it's a very hard judgment for the employer because it basically meant they paid wages throughout a strike, and an unprotected strike at that. Yeah.
All right, I'm going to deal with two judgments to get on track with these slides. Okay, right. I'm going to deal with a strike, a case. It's a Labour Court judgment that deals with the section in the Unfair Dismissal Code of Good Practice. Again, it's a strike case, and as you probably know, that in the Code of Good Practice dealing with strikes, it says in determining whether a dismissal for taking part in an unprotected strike is fair, you've got to consider whether the strike was in response to unjustified conduct by the employer. Okay, now, how serious does this have to be for the employer's conduct to justify the employees going on an unprotected strike? I'm not going to deal with the facts of this case because we need to move on, and we're a bit behind time. It says this, an employer's conduct must be egregious. This is what this Imlondo electrowave case said. In other words, it's got to be shocking or appalling. So there's a high level placed on the employer's conduct before it could be seen to justify an unlawful strike by employees. In this case, interesting, I'm not going to go into all the facts, but the court believed that the lawyers had presented a contrived version of the facts, and they awarded a cost order on a punitive scale to be paid by the lawyers. Okay, damn the lawyers in this case, as they presented a contrived version of the facts. So the court was obviously particularly angry with the behavior of the lawyers in this case. But I want to move on and spend more time on the next strike judgment. Just give me a section, I'll find it in my notes. And this is, it goes to the extent of whether an organization is liable for the acts of its officials. Now, that might sound quite legalistic, but have a look at, think about the facts of the case I'm about to give you. This is involving SPAR, okay? And a SPAR employee was demoted from floor manager to a cashier. As a result, Mr. Sono, who's an EFF local branch official of the EFF, addresses a letter to SPAR management, and he requests a meeting to discuss this. SPAR doesn't respond, they ignore him. He writes again, and this leads to a protest where Mr. Sono, who's the EFF local branch official, effectively shuts down the SPAR. SPAR dashes off to court, gets a restraining order, and the EFF appeals the restraining order to the LAC on the basis that they never mandated their branch official to conduct himself in this manner. So think about this. The SPAR gets a letter from the branch official on an EFF letterhead. What I also didn't mention is that they then phoned or communicated, they might have emailed or phoned, I can't recall which, the national office of the EFF and said, listen, this is going on, please do something about it. And there was no response. The Labour Appeal Court, and let me tell you what they said. Sorry, they treated it under the heading, under the legal term as ostensible authority. Did the branch official have the authority to act on behalf of the EFF in this matter, in the manner that then enabled SPAR to hold the EFF liable? And I'm not going to give you all the requirements of ostensible authority, but the one that was pertinent in this case was that ostensible authority requires a representation by words or conduct made by the principal, in other words, made by the EFF, not by its agent, not by the branch official, that the agent had authority to act. And because the EFF had never represented to SPAR that the branch official had the authority to act, they said the EFF could not be held liable, and the LAC overturned the order that had been granted against the EFF in this matter in favor of SPAR. Again, we are incredibly frustrated by this judgment. I mean, I just don't think it deals with the realities on the ground. You are a business, you get a letter from a union or the EFF on a letterhead. Surely you're entitled to take that person is acting on behalf of the organization he purports to represent. The LAC in this case said, well, the fact that SPAR wrote to the head office showed that they were uncertain whether the branch official had authority to act or not, and it showed that they were uncertain about it. We don't agree with that conclusion at all. I think what they were trying to do is write to the EFF and say, do something about this. Your branch official is behaving in this way. He's caused our business to be closed. It's not in terms of the Labour Relations Act. Do something. Yeah, I mean, we are frustrated where this case leaves an employer in similar circumstances in the future. I think all you can do is potentially write to the organization at a national level and say, please confirm whether or not this person is acting on your authority or not. And unless we hear from you to the contrary, we're going to take it that he is or she is acting on your authority, and we're going to take action against you as an organization. I think that potentially is a way of closing the door on what happened to SPAR in this instance.
Yeah, there are many different dimensions to this issue of who's taking action against an employer. Just as a heads up, in our next newsletter, there's a case involving the ANC Youth League. That's not a trade union at all.
Yeah.
And how the difficulties the employer had in dealing with a non-union party.
Yeah.
So it's ongoing.
All right. We as I thought, Alan's been extremely long-winded, and we've taken longer than we thought over these cases. Perhaps we should deal with one judgment each. That's the end of the strike judgments that we want to deal with.
Yeah.
Do you want to deal with the retrenchment judgment?
No, I'm going to do employees holding political office.
Okay. Well, maybe deal with the let's deal with three.
Okay.
Deal with the retrenchment one first.
All right.
And then I'll deal with one, and then you can.
There was a judgment from the PE Labour Court, which we found really to be out of step with the understanding of what happens in a retrenchment. As you know, the whole purpose of giving notice to in terms of section 189.3 is to start a process of consultation, a good faith process where you try, and there's consultation, not negotiations understood, but a lot can shift in that process. And this case all hinged on who the employer sent the notices in terms of section 189.3.2. It wasn't clear how many employees it would actually retrench and sent to a wider number. That had a difficulty because it triggered a possible section 189A process. Leave that aside, but the employer, well, we often think that there can be all kinds of reasons why the people you think are going to be retrenched might not be. There could be bumping. There could be an offer from the union to cut wages. All kinds of things can happen in the process. But this court was very critical of the fact that the employer sent a notice to a wide group of employees saying you're likely to be affected, and only retrenched a smaller number. And so...
Shall I bring up the case?
Yeah, please. So it's the principle is, we're going to go straight to that. It said the principle is that the Labour Action Act does not intend two employee categories. In other words, those who get the notice and those the employer contemplates retrenching. Now, well, I think this is, I don't know whether the judge ever had experience of on-the-ground consultation. And sometimes I think it's difficult for the employer to know in advance with any level of definiteness who will be retrenched. Yeah. So we think this is the learning is only give the section 189 notice to those who contemplate retrenching. That might not be precise anyway.
Yeah.
Yeah. Okay.
Okay. All right. I'm going to shift tack. I think this is probably the last case I'm going to deal with. It deals with arbitrary discrimination. As you probably know, several years ago, the definition of discrimination under the Employment Equity Act was expanded to include on or any other arbitrary ground. And there's been a debate since then on whether a narrow or a broad interpretation should be given to this. And the courts have generally followed a narrow interpretation that this does not mean that any arbitrary action by the employer should constitute unfair discrimination. So arbitrariness per se is not outlawed by the definition. It's got to be linked to a ground that's similar to, analogous to the listed ground of sex, race, gender, etc., etc. Well, I personally haven't always agreed with this, because if something is arbitrary and it doesn't make sense, it's arbitrary, it's surely that might constitute unfair discrimination. But what's happened in these cases is that the employer, in many of the cases where arbitrary discrimination is alleged, takes the point that, well, no, a ground has been identified by the applicant that is similar to or comparable to the listed grounds. And it requires the it requires the employee to identify a comparable listed ground under which you're bringing the claim for arbitrary discrimination. Now, I mean, I think in many cases, the employee is justified in saying, it's arbitrary, don't ask me, ask the employer. They're the ones who discriminated against me, ask them why they are doing it, don't ask me. But many cases, notwithstanding, have been kicked out basically because the applicant couldn't identify the arbitrary nature of the alleged discrimination. Well, here's a case. This case involves the Chief Director of Labour Relations, who controversially sued the Department of Labour, claiming he'd been arbitrarily and unfairly discriminated against because he wasn't paid the same as others in his department. He was paid on a lower scale when he was doing the same work as them or work of equal value. And the department, again, in this case, tried to strike out his application because he hadn't identified a ground similar to those of the listed grounds. And the court in this instance said no, and they allowed him to bring his claim for unfair discrimination. And I think it's an interesting case. And the court said the fact that the actions of the employer impaired the human dignity of this person, that in itself made it analogous to the listed ground. So it's the impact of the discrimination on the person. And the court said it didn't have to sound like or look like the listed ground. It didn't have to be identified as sex, race, gender. It was the impact of the unfair actions of the employer that allowed it to be brought under the claim for arbitrary discrimination. So I think this, and there's a similar case, there are two cases of this sort, which have come to a similar conclusion in the past year. And arguably, I think these cases widen potential claims for arbitrary discrimination under the Employment Equity Act.
We've got a poll question now, Bruce.
Have we?
We've got our last poll question.
Okay, let's ask you a question. If you all still awake.
Question is an employer entitled to prevent an employee from being an official of a political party?
What do you think?
Oh, look at that. A strong no. Oh, there's a few yeses. Just the wording's important. It says an official of a political party, not a member, all right? But you voted now. Do that.
All right, I'm going to give you 5 seconds more. Make a guess at it, see what you think. Share the results. 91% of you say no.
All right.
All right.
So I don't know if you know this, but the Local Government Municipal Systems Act has for many years prohibited municipal employees from holding office in a political party, but it's limited the people who may not hold office to senior management. In 2022, suddenly there's an amendment to the Act which prohibits any employee from holding office in a political party. As I hinted at when the poll was going on, it's not being a member of a political party holding office. And the reason why this amendment came in 2022 was it was being experienced around the country in municipalities. A fairly junior employee who held office in a political party was able to exert a lot of pressure on senior management in the union, in the municipality. And they wanted to try and make municipalities far more sort of accountable, more productive, more efficient. They wanted to try and cut out this kind of political leveraging within municipalities. Well, this matter was taken to the Labour courts, And maybe we can split up the finding. It's a very strong one. That Section 19 of the Constitution guarantees the right of every citizen to make political choices and participate in the activities of a political party. So this was the basis for them finding that the act was unconstitutional, that you couldn't take away from the right from ordinary employees the right to hold office. Interestingly, the case didn't deal at all with how much time an employee might take secretly to hold office in a political party. But the attempts to depoliticize and stop and to try and professionalize municipalities seems to have failed.
Yeah, Alan, the case obviously is about the public sector.
Yeah.
In the private sector, I mean, wouldn't you apply the normal test? Is what, to the extent that someone's involved in outside activities, what impact has this got on the work environment?
Yeah.
And it might be because of the amount of time that's being taken on these other activities. It's not justified. You cannot do both jobs, or by being an official of the DA or the ANC or the EFF, what impact does that have on your market, on your customers in the business? I mean, those would be, and it would obviously be determined on a fact-by-fact basis.
Exactly.
On the facts of each case.
Yeah. Certainly, it might really work to the detriment of the employer.
Yes.
Yeah.
All right. That concludes the number of cases that we've been dealing with. We've been going for over 75 minutes, which was what we tried to limit ourselves to. Let's look at the questions that have been asked. What happens in a situation where employer A, mother's employer, has a more favorable maternity leave benefit, and employer B, father's, does not have the same benefit? Does the mother have to share her 6 months with the father? Alan, looking at the conditions in a particular organization where conditions are more favorable, but they discriminate between males and females.
Well, I think that what the impact of the Van Wyk judgment is that even when the employer has a better deal for mothers than the Basic Conditions of Employment Act, I think this principle of equality between the father, who is going to be the nurturing parent, and the mother, who's going to be the nurturing parent, I think is now going to be the equality. That's my reading. Is that what Bruce?
Yeah.
So I think that there's now going to be an awareness that there are men who are prepared to be the nurturing parent and should be entitled to what used to be called maternity leave, now going to be called parental leave.
All right. And there's a comment by Merle saying she's got no sound. Well, hopefully, she says not sure if that's on her side only. Hopefully, it was only on her side and not on our side. If the question is, if an employer does not intervene and leaves the relationship to deteriorate, surely the employee can claim constructive dismissal. What do you think, Alan?
Well, Bruce, I think it's your comments at the end of that case, where the employer did nothing, didn't call in a facilitator, mediator, anything. I think that answers that question, because the employer's done nothing. And I think that does open the door to constructive dismissal. Don't you think?
Yeah, I do. Yeah. Again, there's a question on the Westbank case and constructive dismissal. Would it be different if the employee complained to their employer about the other employees causing an intolerable situation, and the employer does nothing? I think yes. I would agree.
That makes a big difference.
Ingrid, I would agree with you. Well done. Again, Ingrid, on the Amitu case, taking the definition of strike into account, namely withholding or retarding of work, violence would then turn the strike into something else, because the employers are not merely withholding their labor. Okay. Well, I mean, I think certainly, I mean, I think it's obvious that misconduct during a protected strike can be dealt with as misconduct. I mean, the fact that a strike is a protected strike does not in itself prevent action being taken against employees who have committed misconduct during the protected strike. I think the case that we're looking at and the argument that we're trying to put forward is that if there is extensive violence during the protected strike, in our view, that should have the potential to create and render that strike as an unprotected strike.
Yeah, I agree.
Yeah. Alan, you can read the next one.
Maybe you can.
What about parastatal companies in terms of employee becoming a political official?
Judge, parastatal companies. Well, I think the definition of a trade union is pretty clear, and I think
I don't think it makes any difference whether it's a parastatal company.
No, because you've got to register as a trade union, and I don't think any of, like the ANC Youth League and the EFF, they're not registered as a trade union. That's the issue in those cases. Yeah.
Yeah. Will the view or answer be different if the breathalyzer is accompanied by a confirmation testing indicating the percentage of alcohol in the blood system? I mean, I think that goes to one of the points that we raised, that you should need that kind of evidence about the dependability of the test. But what that case was saying is that breathalyzers in themselves may give you a false positive under certain circumstances. So even if the test is working perfectly, it would seem from that case that where someone hasn't eaten potentially for 8 hours before undergoing a test, or whether he or she's eaten something containing yeast, it could well give you a false positive, even though the machine itself is working well, etc., etc. So I think the guidelines that we put forward under that case are useful in minimizing the potential for things going wrong.
Yeah.
Yeah. The comment is made that if in that case about the EFF, I think it was the SPAR case, if EFF National is not responding, does that mean that they are not held liable? Again, I didn't make the comment that I didn't agree with the Labour Appeal Court's views on that at all. I mean, I think that the fact that they had contacted the EFF on a national basis, in my view, places some obligation on the EFF to get involved and do something about what its branch official is doing. It's not, as the Labour Appeal Court appeared to conclude, that showed that SPAR was not actually sure whether that branch official had the authority to act or not. I mean, I think that was...
I think this question is asking something different. Say you do reach out as the employer to the head office of the EFF,
Yes.
and they don't reply.
Yes.
But I think you said in your presentation, you should say to them, if you don't reply by a certain time, we're going to assume that you have authorized this.
Yes.
And that becomes just part of the evidence of, yeah.
All right, questions are pouring in. Thanks for the compliment, Ingrid. Okay. Any other questions? Yes, there is one. What happened to the document on violence in the workplace and during strikes, which could have become a code of good practice?
Well, there is a code of good practice.
There is a code, Jan. It's up on Work Law. It's got a long-winded name. I can't remember what its name is, but there is a code of good practice that exists, and it's up on Work Law that should regulate conduct during strikes.
I think it came into operation in 2022, but it's in no case after that have I ever seen it referred to.
Haven't you?
No.
Yeah.
And of course, you know that what the Labour Relations and Basic Provisions say, that any decision maker is obliged to take into account relevant codes of good practice. It's almost as if people don't know that code is in existence.
Yeah. All right. I think there's one more. An employee withdraws his appeal in the company, but he refers it as a dispute to the CCMA. Can I declare his case null and void? I think there's a case, and we actually I'm not sure if you're the same person who lodged the helpline query on this recently, but I seem to recall there was a case I couldn't find when we answered that helpline query, where the court, and I can't remember whether it was the Labour Court or the Labour Appeal Court, said that an appeal which, by the way, is not mentioned in the Code of Good Practice for a dismissal. You look at whether there was a fair procedure to dismiss, and there's no obligation on an employer to hold an internal appeal at all. But I think there was a case that said that is a right given to the employee to exercise should he wish to do so. The fact that he doesn't lodge an appeal should not bar him from then exercising his or her rights to refer a dispute to the CCMA. Look, I think it also depends on the policies and procedures of the employer. If these are being negotiated and agreed with the union, and they contain, for example, a clause, I'm making it up, that an employer is not allowed to refer a dispute to the CCMA until they've exhausted internal procedures, and that's been agreed with the unions and it's been incorporated into employees' terms and conditions of employment. Potentially, you could then use that as a basis for taking exception to an early referral to the CCMA. But again, what's the point? Because if the person then comes back, appeals, loses the appeal, it's going to end up at the CCMA anyway.
Yeah. No, I mean, I looked on the CCMA website, thinking they might say we don't have jurisdiction if you haven't used the domestic appeal. They just say we urge you to use domestic appeals before applying. They don't say they won't have jurisdiction.
Yeah. All right, there's another compliment which we accept gratefully. Thank you very much. Thank you, all of you. We hope that you've enjoyed it. We hope you've benefited from the points that we've made. And, you know, in talking about these judgments, these cases from the last year, one always says, well, how does this impact on how you manage people at work? And so what we try and always do is focus on the learnings that then affect how you manage your labor relations. And I hope we've achieved that in trying to draw out those learnings from you and always make it practical by referring back to how this impacts on you in the workplace. If there are any questions which we haven't answered, please feel free to use the Work Law helpline and we'll deal with them as best we can. So thanks for attending. I see we've still got a large number of people who are present. Thanks for hanging in there for the full duration of the webinar, and we'll get the material from the webinar up on the Work Law website as soon as we can. Thanks very much. Enjoy the rest of your day. Bye.
Bye-bye.